You are now listening to Comp Corner, brought to you by the law offices of Bradford and Barthel.
What is up? Welcome to Comp Corner. It's your favorite defense attorney and host, Nasser F. Adil. On today's episode, we have the pleasure of being joined by managing attorney of our San Jose office and partner, JP Torres. JP is an aggressive and experienced defense attorney who has been with Bradford and Barthel for over 6 years now. On today's episode, we talk about how to best combat permanent disability. We also discuss the art of mitigating exposure by effectively communicating settlement recommendations throughout the course of a claim. And please be sure to stick around because a little later in today's episode, we get to know JP a little better by asking him some 5 and 5 questions during our 5 and 5 segment. Please be sure to email your comp and podcast related questions to Comp Corner. Our email address is in the show notes below. Later in the episode, I'll answer a recently submitted question from Comp Corner supporter and claims examiner, Neil. And without further ado, on to our guest. All right, welcome JP Torres, managing attorney of our San Jose office and partner with Bradford and Barthel. How are you doing, JP?
Good morning. Great. How are you?
Doing great. Thank you for your time on and appearing on another episode of Comp Corner. When did you start with our firm, JP?
2018, Q4 of 2018.
So JP, as far as your background and experience, I think you have an advantage that serves you quite well in your defense experience. You started off as an applicant attorney, is that correct?
Yes, I was. When I first started comp, I was an applicant attorney for almost about 2 years, give or take. Yeah. My first foray into comp without any experience whatsoever. I don't know about most people, but I did not come from a medical background, right? So these terms that we first got into, learning comp was so foreign. It's so difficult. And I mean, if we talk about it later, when I'm training new attorneys, especially who do not also
Yeah.
come from a medical background, just laying the foundation for the things we see on a day-to-day basis, it can be a very steep learning curve, right?
Oh, yeah. We use a lot of acronyms in comp, and it's funny because until you discuss kind of comp with someone who really isn't comp, and you just kind of talk about comp in general, they're like, hey, what does PTP, AME, RFA, sheesh, who knows
Yeah.
how many extra galore, WCJ, WCAB. None of us knew what these terms were before we got into comp, but holy smokes, there are tons of acronyms, right?
Right, and it seems like every time we're training a new attorney, they're asking for the cheat sheet or whatever because then
Yeah,
we've gotten so used to our shorthand that even when discussing basic concepts with them, you can see the eyes kind of glazing over, the deer in the headlight look. They have
right.
no idea what's happening, and then you got to slow down, back up, and go, okay, apologies, let me start again, and let's slow it down and break it down so you can even understand the vocabulary we're talking about, right?
Yep.
Just there is hard.
The lingo alone, I mean, MMI and PNS meaning the same thing is pretty complex, but in our day-to-day life, we kind of just take it for granted because it's something we deal with every day. Now, I always think that there's advantages that those who have worked on both sides, either an applicant attorney working in defense or the other way around, where a defense attorney acting as an applicant attorney. I think there's really big advantages in having that perspective on both sides. What are some advantages that you'd say you have currently working as a defense attorney where you got only because you formerly worked as an applicant attorney?
Right. I think starting off as an applicant attorney and then transitioning to defense, I think I've been able to sort of see uh, what happens behind the curtain. And I can
Mm,
explain that in this way. When I first started as an applicant attorney, it almost seems like there was kind of this indoctrination that the defense side was this big bad boogeyman out to get the
right.
poor applicant, right? But coming over to this side, we find that that's just simply not true. There is
Sure.
the vast majority of our clients, the claims adjusters, are just there to do their job, make sure that the benefits are paid out appropriately, right?
Yeah.
And there is nobody has the time to try and do this grand conspiracy, right? We're all
Right,
just
right,
here
right,
to
right.
do a job, administer these benefits, and get the person well and on with their life.
Sure.
But
Benefit delivery system, right?
exactly, exactly. But to this day, I go against opposing counsel who they they have it in their mind that there is some plot or conspiracy against them, and you can see that their litigation strategy somewhat follows that. One of the examples I had was I had a employer who is a big employer. So their TPA, also a giant TPA, one of the titans of our industry. But that TPA is an arm of a larger company who has
Uh-huh.
multiple branches. It's not just comp. They do long-term disability, short-term disability, and other benefits they administer. And it just so happened that this employer used the same what's it called? Not a sister company, but another a subsidiary of the
Hmm.
same company to
Sure.
administer their return to work program, right?
Hmm.
But in this particular case, that applicant attorney was convinced that there was uh, some kind of uh, collusion between the comp portion and the return to work portion to I don't know what, so artificially create jobs that so that the person can go back to work. Is
Right.
that a bad thing? I mean, I don't. One, the claims examiner couldn't even tell you what was going on in the return to work program.
Hmm.
All he gets on their end is it's either yes or no, right?
Sure.
But here we are, like 3, 4, 5 hearings later, and they're still trying to figure out. They want to take depositions of people on
Yeah.
who's on this return to work program. Like, nobody knows what's going on. I mean, we don't even know any. I personally could not figure out who was on that return to work because it's
Right.
totally outside of our lane. But this is just
Yeah.
one
Yeah.
example of how they're sure there's a conspiracy. They're sure there's collusion. Nobody has time for that.
Yeah.
It doesn't even make sense. But there
Yeah.
it is.
It's easier to call something conspiracy just because you don't want to look at either the reality or look further into what's really going on. So that's yeah. So one of the advantages I always see with AA's applicant attorneys who are now doing defense work is that they have a perspective on settling a case, valuing a case, which is really invaluable as far as knowing what and how much it'll take to settle a case because you're dealing with both sides, right? But when you value a case now as a defense attorney, how does your experience as a former applicant attorney working with injured workers, how does that play into settling a case now as a defense attorney who's been doing it now for 7 years on this side?
I think I approach my settlements more realistically on this
Mm.
uh on this side.
What do you
That's
mean?
not a knock on attorneys who've only done defense work, but I think sometimes not just in our field, in any field, when you're very used to being on one side of the V, you get
Hmm.
very much protective of our side of things, right? So
Yeah.
sometimes that can lead to blinders and, you know, this claim is only worth $1,000. This claim is only worth $1,000. Claims don't settle for $1,000, right? I mean, you have to have a broader understanding of what concerns both sides have so that you can come up with a settlement that is reasonable that will get it done. There was
Sure.
an anecdote that I was told as a very young attorney that if both sides to a settlement are happy, that means it was a bad settlement all around, right? That,
Exactly.
if everyone is a little bit bruised, a little bit upset at how it played out in the end, that means nobody got everything that they wanted at the end. So therefore, you probably arrived at some kind of happy medium. I mean, it might not be a happy medium for your client, probably not a happy medium for their client, but you got
Sure.
it done. That means you didn't throw away everything in the kitchen sink, right? So you
Yeah.
still reserve some, they still reserve some. And I think starting off as an applicant attorney, you get kind of an idea and at times the unreasonable expectations that applicants may have that we never really see on our side, right?
Yeah.
You'll have before I became an attorney, I worked as a paralegal doing immigration work. And a lot of times you'll hear stories about like, oh, attorney, my uncle's brother's cousin's nephew, they had the same exact case, and this is how it played out. And as an applicant attorney, I was like, wow, same story, different practice area, same thing, same thing. So you get sometimes these unreasonable expectations. We don't see that. as on our end, right? Because our clients are very, sophisticated business entities, right?
Sure.
But they don't
Sure.
see that how sometimes maybe an unsophisticated or maybe naive applicant will have these ideas, not realizing that, comp is a very structured, regulated system. We all know the money chart and the, treatment costs what they cost, right? So,
Yeah.
but you'll see sometimes that without having that exposure, especially when you're starting out as a new defense attorney, for example,
Mhm.
valuing the cases can be tougher, and maybe trying to see why the other side is not agreeing to your very reasonable offer. You're like, why is this not working? That I think that really helps seeing both sides.
Yeah, seeing the perspective is really key on that. I mean, it's funny because, doing defense work now, I've done it for about 15, 16 years. You've done it for defense work for 7, 8 years. You get to know other attorneys, you get to know judges. And in doing some of the settlements, you'll have good rapport with AAs that you can move cases forward with. And every now and then you'll have an AA applicant attorney that you work well with, and they just say, "Hey, Nas," or "Hey, JP, I just can't get a deal done." And you're like, what's going on? Why not? Here's the PD, here's a future medical valuation. And they're honest. They're like, look, my client, meaning the injured worker, they're watching TV, or they have a neighbor who had double the injury and sorry, half of the injury, and but double the money, which means that, hey, they know someone who had half the pain that I have, but they got triple the money. And you're like, sheesh, every case is different, right? We don't exactly have a set formula, which is a good thing. We want to have every case looked at properly. But also, like you said, it's called a compromise and release for a reason, right? What does compromise mean for those of us who are married? It means, guess what? You don't always get your way. If you did want to get your way, then go to trial. But a compromise is that you give some to get some, and vice versa, right? Then you release and you move on. So that perspective is really important. Thanks for sharing, JP.
Did you know there is an 8 in 10 chance that the whole person impairment found in your medical legal reports is inaccurate? As a result, benefits are often grossly overpaid, including unjustified life pensions. B&B's AMA Guides Analysis and Rating Department has reviewed tens of thousands of PTP, QME, and AME reports verifying these troubling statistics. The results confirm that 79% of reports misapply the guides to overvalue impairment, 2% undervalue impairment, and the tiny remainder is actually accurate. B&B's experts have decades of experience analyzing physician reports and outlining their shortcomings in applying the guides and legal theories such as Kite and Almaraz Guzman. Our services help prepare parties to cross-examine physicians and draft legal arguments to ensure that the benefits you deliver are correct.
Now, we want to focus today a little bit on, the aggressive handling of a file and combating permanent disability. What are some things that at the outset of a claim, JP, you recommended that you do in your file handling to be aggressive, to limit, and to combat permanent disability at the outset of a claim?
Sure. So when it comes to limiting exposure in this particular scenario, permanent disability, I generally take a look at when I get my file. Was there an ISO report? Are there any non-industrial medicals that were provided? And if not, how can we find that, right?
Sure.
Because to limit PD, of course, we're looking at things like, are there other potential causes for the injury? AOE, as we all know, AOE COE is a very low burden. So really,
Hmm.
if we can't attack AOE COE, then we're left with just apportionment. So how do we get additional information to prove that apportionment, to even suss out where can we find said
Hmm.
apportionment, right?
Hmm.
So the ISO claims report is great at first. I like to try and get that even before the deposition because it'd be
Oh,
it'd be
yeah.
nice to be able to verify the testimony. I like to see if the clients our clients, the claims adjusters, were able to get any perhaps non-industrial medicals before the claim was referred over to us. If not, not necessarily detrimental. We can always do a deposition. But what information did they get in their initial file
Hmm.
investigation that we could
Yeah.
use uh, If allowed by your client, I like to talk to the employer, see, hey, is there what happened here? Can you give me
Mhm.
some background and some information? Sometimes the employer will have a lot more information about the applicant. Well, not sometimes, a lot of the times, the employer will have a lot more information than our client
Oh
because
yeah,
they work with this person. That's their coworker. Sometimes they've known this person for years, right? I mean, think about your own coworkers. As you work with someone for many, many years,
sure,
you get to know that person, about their life, kind of their personal life, how they are in the real world. So that the employer could be a treasure trove of information on just background and context, right?
right.
Which can help.
100%. I think getting the ISO early, getting those records as soon as you can. If you don't have the records prior to the deposition, not the end of the world. You can always get them after the deposition. But the important thing is if you have the ISO report, you can always know which questions to ask at deposition, right? So let's say you have the ISO report, JP, at a deposition. What kind of questions would you ask relating back to the ISO report to try and limit permanent disability as much as possible?
Sure. Generally, one of the questions I'll ask is, have you been in any prior motor vehicle accidents
Yeah.
before? And that is a pretty standard question. I think most defense attorneys will ask that. But something that I generally also do, actually, I learned this from your brother when I was a brand new defense attorney, is you try and expand that because then
Mhm.
for most people in a deposition, I think they're trying to be honest with you, right?
Yeah.
It's very rare that you'll try and somebody who's really trying to conceal. So when you ask them, have you been in any motor vehicle accidents, or if you're trying to be more colloquial about it, have you been in any car accidents, then they'll just tell you
Mm.
car accident, right? They won't mention any perhaps bicycles,
Mhm.
motorcycles, boating accidents are a big one. Boating accidents you see quite often, or you know, we live by the water, right? So it makes sense for us. Of course, one of the ones that I ask, which can get a little bit of a chuckle, but I think is very important. I always ask them if they've been in any golf karting accidents. Golf
What?
cart.
Really?
Yeah,
Interesting.
because especially in our area, we work, or me here in the San Jose area, a lot of tech campuses, a lot of them ride
Interesting.
around in golf carts. Golf carts. Uh, a little personal anecdote. My wife used to work for a major university here some years ago, and one of her coworkers had her own comp claim. How? The lady fell out of a golf cart.
Really?
Because in the campuses, which is a sprawling campus, how do the staff get around? They drive around in golf carts, you
Sure.
know? So, and in a lot of these tech campuses, very large campuses, right? Bicycles, golf carts, what are those called? Those segways, right?
Oh, yeah.
So you see just again geographically know your market, know your area.
Mhm, mhm,
So why having local counsel so important? But here in my area, for sure. Or I do cases with ag workers. I didn't know this until I started working here, but ag workers sometimes will use golf carts to drive up and down the farm
mm,
because they're small. They'll fit between the rows,
mm,
and they can do like inspections of rodents and other
mhm.
pests, right? So yes, I always get a chuckle when I ask about the golf cart, but if you know kind of your area, that the very first death claim I got was
Mm,
somebody under a golf cart. So
mm.
these things you never know. You just never know.
No, that's the best part of depositions is that, you lose nothing in taking them. You really get not only an idea of the credibility and of the injured worker, but you also get to ask these questions where otherwise, if you don't ask them at depo, then guess what? You're giving the medical legal evaluator every opportunity to be the only one where an injured worker tells his or her side of the story. So at deposition, you can ask those questions. And it's funny, I'm going to start asking about golf carts too. Usually, I always ask injured workers if they've been involved in any motor vehicle accidents, either as a passenger, driver, or pedestrian. Now I'm going to start inserting, or as a golf carting individual or not. So that's good. Now, as far as depositions go, the importance of asking about activities of daily living, I think that's huge, right? I think if you don't ask about their activities of daily living at a deposition, then again, you're allowing for the applicant to just really dictate what terms their ADLs are going to control moving forward. And in doing so, if you have a very applicant friendly QME, then that QME is probably going to listen to what the applicant's telling them as far as their subjective ability to perform ADLs, then all of a sudden you're really at the back seat in aggressive file handling. So I always like to ask about ADLs, and in doing so, you can kind of keep them honest, right? Say, hey, look, if you can do all these ADLs now, you're telling me, then guess what? We're going to relay that to the doctor, and we're going to tell that in our cover letters to the QME. Now, before we get to the QME, JP, what do you recommend as far as, taking, you got the ISO report, you have a good, strong deposition. What's the important part as far as the QME process, in your opinion?
I think as defense attorneys, we really have, again, this is my opinion, that I like to be on top of the panel process.
Right.
I know maybe some clients, some other legal professionals believe that, oh, that's purely secretarial work. That really has nothing to do with your legal um, analysis and mindset as an attorney. And I can see what they're saying because, requesting a panel, doing the panel, that is not legal work in the sense that you're not making a petition, you're not drafting a petition. However, you can see that the panel process is just one example of how maybe not pure legal analysis can have an impact on the trajectory of your case. So to me, being on top of that panel, or at least trying to mitigate AA's attempts to get their own specialty,
Sure.
Can have a serious impact on your case. And yes, I get it. We don't always win, and so, recently sometimes we're maybe losing more than we're winning, but that doesn't mean one should not try, and try and limit that because on those ones that you do get a favorable specialty, then it'll help you really move that case along easier, I believe.
Sure. And there's no guarantees if you get an ortho panel for a orthopedic injury. There's no guarantee that that orthopedic panel is going to, contain three super qualified and defense friendly physicians. Same thing with a psych injury, right? There's no guarantee that a psychiatry panel is going to have a list of very defense friendly doctors, but it's all about putting yourself in the best position to succeed, to mitigate exposure, and to be aggressive. But I agree with you. If you're not online trying to get a panel request, when the time is right under labor code sections 4061, 4062, or even 4060, then you're really working on the back end trying to go forward. So you might as well be aggressive, stay on your toes, not on your heels in that regard. Now, speaking of medical legal evaluations, I found that cover letters to the panel QMEs, especially now where the regulations have kind of changed, which allow doctors to get paid for kind of per page of their review, have really helped defense attorneys and defendants in general, because I feel like strongly worded cover letters or aggressive cover letters that are obviously within legal bounds and constraints. But the benefit I found as far as writing cover letters is that they often get read now. Before, doctors weren't reviewing cover letters because they weren't quote unquote paid to review those cover letters. Now, guess what? They're reviewing cover letters. What have you found? What's been your experience with that?
I think you're right. You know, it's funny. I believe the theory behind the per page was that you were going to get maybe a better quality doctors to be attracted to do
Right,
QME work.
right.
I don't know if that's true or not, but I agree with you that I think they are reading the letters more
Sure.
nowadays. And again, you and I, we both practice here in Northern California, and so I can't really speak of Southern California QMEs as much, but definitely I've seen an uptick of them referencing our letters, looking at what
Mm,
arguments we've had, or even the questions we pose in those letters, right? Which
sure.
just a few years ago, it was kind of hit and miss. I'm not saying that they're all reading it now. However, I think you're right. As the per page billing system has come in, I think that you do see them reading it more. The flip side of that coin, though, is I remember back in the day when I first started as a defense attorney, uh, talking about limiting PD, your question earlier. If you get those subpoenaed records, you send everything in the kitchen
Oh
sink
yeah.
to the doctor. 20,000 pages of Kaiser records, all for it. Let's
Yeah.
do it. Let's scrounge every medical from the time they were born to now.
Right.
I can actually tell you, I actually have one of those where the applicant's
Mm,
not very old. I'm sorry, let me rephrase. The applicant's quite young. So somehow I received uh, his medicals from his pediatrician when he was like 3 to now. And before the per page count started, all of it went,
Right.
thousands upon thousands of pages. We're now in our current scheme that we try to be more selective. We really do look at that to see, is this relevant?
Yeah.
Does this make sense?
I think you hit it perfectly. I think the intention when we changed the law was to get, a broader pool of doctors to go into comp, right? To make it more lucrative because you get paid per page for performing a med legal evaluation. And I don't know if that's really turned into a different quality of doctor. But what I do know is you have doctors who review the cover letters, which is great for us because, we can spell out, hey, doctor, look at the record from this hospital, page X. This talks about prior motor vehicle accident, 2 prior work injuries, degeneration, etc. And I think the positive consequence is that you have less need for panel QME supplementals now because the doctors will have reviewed everything at the onset or the initial evaluation. You're not asking them, right after they issue their first report, hey, doctor, can you please make sure you do your job that you should have done back when you first did the evaluation? Can you please redo that work now? You don't need to do that because now they've reviewed everything up front. They've realized, hey, there might be apportionment at the onset. So then they're going to probably take that into consideration and lead to a more reasonable report. I like to stress things like subpoenaed records, like we talked about. If there's surveillance, I definitely put that language into the cover letter. Keep everyone honest at the onset. Say, hey, look, doctor, we have video. We're being aggressive. Just please perform your objective evaluation, but just keep in mind that there is video that's already out there. We want you to consider that in your job as a medical legal evaluator. As far as post depot reports and everything go, what are some things you do, JP, as far as staying aggressive after the initial report comes out from a PQME or AME?
I think you kind of hinted on it earlier. The surveillance is a strong one.
Yeah.
I like to. Strategy is an interesting thing, right? There's no one
Right.
size fits all solution. And half the time, it's always a debate for me in my own cases. Do I want surveillance at all? Do I want surveillance
Mm.
early on or later on? Do I submit these records now or after? Right? Because I don't want, especially it's one of these things where you have a suspicion, and we've all been doing this long enough that you kind of
Sure.
sometimes when you read a file, you have your initial thoughts and impressions on what type of injury this is. Is this an injury? Is this how severe is it? Are we having any kind of exaggeration, malingering, etc.? So I'm a big proponent of surveillance when warranted, right?
Right.
And just like to me, surveillance is just like diagnostics. Everyone seems to really poo-poo on diagnostics, but to me, the more objective evidence one has, the
Right.
better. If it proves the injury, great. Then we know that the client's paying for the exposure that's correct. But
Right.
if it's no objective evidence, then we know where this is going, right? I think it only helps frame our strategy when we have these objective pieces
Sure.
of evidence to show, just like the surveillance. If the app, we are not ever there at the QME evals. So whenever you're seeing the recitation, the history from the QME that was purportedly given by the applicant. They're saying all manner of things about ADLs that you had mentioned earlier. If
Hmm.
they seem to maybe not match with what was it, the deposition or what maybe witnesses have said, then that sub rosa can really help prove or disprove what what's being said, what they're alleging, right?
Right. And not all surveillance is helpful. We all have cases where we've seen where you might recommend video and it may just be mediocre, and that's fine. But I think the more objective evidence you have, like you said, JP, it helps the applicants, it helps the insurance carriers, and also it helps judges, right? So you go to the board at trial, and if you have objective MRIs, objective video, it kind of does it is best evidence right there for everyone to know what the actual exposure and what the overall case value really is. As far as post PQME reports or AME reports, I often also get supplementals just to clarify the whole record to make sure that everyone has a complete record. And I'll take a deposition as well if need be. And it depends on the issues, of course, right? Sometimes you got to take a doctor depot to really restart the wheel because the doctor's so lost, or you just want to finalize one or two issues. But in an average year, how many doctor depots do you take, JP?
Uh, Probably maybe like one or two, maybe 1 to 3 every month, give or take.
Yeah.
So whatever that translates to. Sometimes more, sometimes less, but you know, about that.
Yeah, I take probably between like 4 and 8 a year.
Actually, yeah, and thinking about it, I should probably change that answer. 'Cause 1 to 3, that seems a bit excessive. I'm looking at my own
That's
count
fine.
like that. That seems no, but I don't think I take that many. In my mind, it seems like a lot, but i you're probably right. It can't be that many. They don't all
Could
get a
be.
doctor depot.
You guys take a lot more. You guys take a lot more in San Jose than we do. I think my brother's style is more doctor depots than not. I don't take that many, but there's no right or wrong answer. I think you're fine if you take more or I take less. It doesn't really matter too much.
Right. Always the training I remember when I was new from your brother is always like, the doctor deposition is not really to change the doctor's mind, right? The doctor has the
Exactly.
opinion that they're going to have, right? You just want to test, was that opinion formulated properly using the evidence in front of them, or did they have maybe some not prejudice, pre-existing notions about where this case is about or what it's going, right? You want to see, did they really look at this objectively, and was their findings reasonable
Sure.
or not, right? So that a trier can rely on it to issue an award later.
Yeah. Yeah. One example I always give to attorneys, I'm like, look, we're not doctors. For us to kind of try and educate the doctor on medicine is a really high uphill battle, right? But at the same time, our job as attorneys is to not necessarily change the doctor's opinion, but if we can just prove their opinion is not substantial medical evidence, then we've really hit gold, right? So if the doctor is insistent on saying, "Hey, the sky is red," and you're like, "Doc, look outside the window. The sky is clearly blue. How can you say it's red?" And the doctor sticks to his or her guns. They're like, "Nope, I'm looking out. The sky is red mixed with orange and purple flurries." Then that's actually good. You know why? Because if a judge later sees that testimony or that transcript, they're going to say, well, clearly the doctor here is wrong. The sky was not red, orange, or purple that day. It was blue that day. Then you've done your job as a defense attorney, right? So it's all about not necessarily changing the doctor's opinion, but sometimes just showing that opinion does not constitute substantial medical evidence.
I think that's exactly right. Something that I like to tell my new attorneys is you're not going to out doctor a doctor, right?
Exactly.
That's just not going to happen. Your job as an attorney is to find out, is that report, is that deposition, is that substantial medical evidence? That's a legal question, right? That's our
Exactly.
wheelhouse, but if you try and out doctor a doctor, that's not going to happen, you know.
Imagine if they tried to out lawyer a lawyer, right? They would just get shot down right, within the first 3 seconds. Same thing with the other
Exactly.
way, like you said. Here on Comp Corner, we love interacting with the comp team. That includes employers, risk, claims, TPAs, etc. When your email is read during an episode, our client relations team will send over some gear as a thank you for participating. Neil asks, I have a case where the panel QME's permanent and stationary report issued a few weeks ago. Overall, it's a reasonable report, but I don't think the panel QME properly addresses apportionment. Opposing counsel has sent a demand and indicates they'll file for a mandatory settlement conference. I want to request a panel QME supplemental addressing apportionment. Do I have the time to perform additional discovery? Great question, Neil. For the answer, let's review due diligence when performing discovery. To this, we review Labor Code Section 5502.3, which states, quote, discovery shall close on the date of the mandatory settlement conference. Evidence not disclosed or obtained thereafter shall not be admissible unless the proponent of the evidence can demonstrate that it was not available or could not have been discovered by the exercise of due diligence prior to the settlement conference. Now, Neil, the definition of due diligence is not defined, but there is case law which establishes that if a party has knowledge of facts required for the discovery before the mandatory settlement conference, the WCAB will not allow the evidence to be obtained afterward. Another case rules that a party would not exercise due diligence if it knew of defects in the medical reporting, but did not cure the defects before the MSC. Now, the pro tip here, Neil, is get your proposed letter out as soon as possible. That's going to prevent a declaration of readiness to proceed being filed by opposing counsel. Now, even if opposing counsel files that DOR, you can timely object to the DOR by showing you've requested the panel QME supplemental. Pro tip number 2 is to attach your letter requesting a supplemental as an exhibit to your declaration of readiness to proceed objection. By doing this, you'll demonstrate your attempt to cure the defects relating to apportionment before the declaration of readiness to proceed and, of course, before the mandatory settlement conference. Thank you, Neil, for your question. And now, back to our guest. Now, as far as combating PD, in reality, as in defense, we're also trying to mitigate exposure as much as possible. And with mitigating exposure, that, in my opinion, comes to try and settle a case throughout the different stages of a claim. What's your experience with mitigating exposure and reaching settlement throughout the course of a case?
Sure. I think there are always obvious goal markers or signposts where one would want to try and settle a case, a deposition right after or right before a QME, those of course make sense. But I think when it comes to just limiting exposure as a whole, sometimes we forget that sometimes even paying a little bit of money up front is a way of limiting exposure. And let me kind of delve into that from my own personal
Sure.
experience. We've all done this long enough that these claims do not get better with age. I think that's so well known that it's kind of like a workers' comp cliche at this point, right?
Workers' comp claim is not like fine wine, as they say, right?
Exactly. It's so well known. I think in as many years I've been doing this uh, one claim out of the hundreds that I've ever done have gotten improved in the 15, 20 years it's been open, right? I think
Sure.
that claim was so old that we had QMEs retire in the middle of it, right before it finally resolved. And that was the only claim, one out of hundreds
Mm,
that improved with age. So you always never want to fixate on the one. Because yeah, there's always going to be the one that got better, but what about the 99,
right,
105 that did not before that one, right?
right.
So sometimes we have to get a little bit of perspective here. And if we need to pay a little bit of a premium to shut it down today, now, as opposed to doing another 18 months of discovery, that is aggressive file
Yeah,
handling, right? Know when to cut your losses and try and shut it down. I think that's one of the biggest keys that me as a trainer, when I discuss with new attorneys, is know how to value that case. And if the demand and your valuation has a little bit of a gap there,
yeah,
know where is reasonable within that gap. I call it the premium to shut it down today. What is that, and where are you willing to go to shut it down in anticipation of how much is it going to cost you 6 months, 18 months down the road, you know?
sure.
So
I think there's 3 big things on shutting a case down. I think it's all about communication. The second is communication, and the third is communication. Duh, same answer. But as a defense attorney, if you're not communicating the level of exposure at the beginning, middle, and end of a claim all throughout that point, then you're really not giving a proper estimation to your client on how to settle a case and close down a case, right? As we talked about on this podcast prior, the best file is a closed file, but the case valuation can change from when the case first happens in X month. That case is going to be worth something different 6 months down the line, 2 years down the line. But as long as we're communicating with our clients at the beginning, middle, and outset of a claim, then it really allows our clients to mitigate exposure potential as much as possible, right? So I think what you said is exactly perfect. Communicating to the client, telling them, hey, if we can get this done for maybe 60 cents on the dollar right now, rather than paying the full dollar in 3 months, then that gives our clients the opportunity to maybe take advantage of that. And then it's all about striking while the iron's hot, right? If the applicant will take that amount right now, and if we get authority for it, you got to move fast. Shut a case down, close the file out. And that's really successful file handling, in my opinion.
Yes, exactly. And again, like you said, sometimes it's hard to value a case early on, middle on, at the end. So you may sometimes get a surprise, right? If the QME just is completely has a nonsensical report, sometimes you can't anticipate for nonsense occasionally, right? But
Right, right,
for the vast majority, you should sort of be able to get a feel for where the claim is going. But again, like you never want to focus on the exception, right?
yeah,
Go for the odds. If the vast majority of them go a certain direction, you know, yes, one or two may be outliers, but those
right.
happen. It does, you know.
Sure. No, thank you, JP. Now, in March of this year, we're going to be going to a video system for our WCAB hearings. For the last 5 years since COVID, we've been remote, for the most part, for hearings, with the exception of in-person expedited and in-person trials. But we're going to be going to a video system soon, which is going to be a fun transition over. Now, for the last 5 years, JP, what's been the most random place you've called into a hearing from?
Probably on the freeway, where I got stuck in traffic one time, and unexpectedly the 8:30 call was about to start. So I'm doing my mad dash trying to call my secretary, having her connect me to the board because I can't be doing like 800 numbers with pins and
Right, 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 right.
because that's just no. So that was the most random spot ever. Well, not just in hearings though, in since the post-pandemic virtual system has happened, our virtual depots, etc. You know, I've had to, I've seen applicants try and do depositions while driving, and I have to
Mm,
stop the thing and go, no, no, we're not doing this, right?
yeah, yeah,
I'm not taking a deposition with you clearly driving. I can see the scenery moving, zipping by on the window next to you. This is not happening. So definitely there have been some strange places, but for me personally, probably taking a call on the freeway.
yeah. I've taken all my hearings either at my home office or at the actual office. There is a one or two exceptions where I got a call from a client at like 2 p.m. on an afternoon, and they said, "Hey, are you free?" I said, "I'm driving. I'm picking up some food for my kids, but sure, what's up?" They're like, "Hey, we have a status conference that needs coverage right now. Can you please call in?" I say, "Sure, I'll call in." Meanwhile, I call in, the judge is fine. And I had to be honest with the client. I said, look, I'm driving with my kids right now. And I ended up taking a hearing partly when I was making a food order drive through at In and Out. Am I proud of it? No. But hey, does it happen? Yeah, sometimes you have to do things that are sporadic, but it's a little bit about, hey, you got to be available and really adjust with the times. And I think with the video system coming into place in March, which at time of recording has not yet been instilled, but it's going to be a nice little learning curve for us, right? Get to see faces again and just have that connection. And it's worked in different courts throughout the system and criminal, family. So I'm looking forward to it taking place in comp. What do you think?
Yeah, definitely. And it'll be kind of a throwback to when I first started practice and when I was a law student, where you have a extra set of, court clothes in your office, right?
Yeah,
Because,
right.
now there's nowhere to hide, right? Even in these MSCs, status conferences, if you need to be court appropriate when you
Yeah.
go, I do have my court clothes here, in the office. So you just quick change and then do it, just like the olden days, right?
Yep. Back in the day, you'd have to run to the board and put a tie on for a walkthrough. We're going to have to go back to that, which is, it's going to be a welcome transition. I think it's going to bring the personal element back to comp, which is a big part of what we do. It's going to help you connect with the judge, with opposing counsel, with lien claimants. I think it's going to continue to help us keep costs down, hopefully, as far as settling cases, continue with that positive uptick in trend. And it's going to get us back to basics. Hey, let's go into a meeting room. Let's go talk about settlement. Let's set a case for trial here. But I think it's going to be a welcome transition. I think as a community, workers' comp wise, I think we're all ready for it.
Yeah, I think so. But kind of an interesting adjacent to that is that as more things become virtual, some things are still incredibly static when it comes to in person. I think you'd mentioned the
True.
expediteds and trials earlier. So at least from my personal experience, I found that judges are still very hesitant, very resistant, very hostile even
Hmm.
towards any kind of virtual trial or expedited. So going kind of leading back to your earlier theme on limiting exposure. If a case is going to trial, and in the post-COVID world, remote work is quite rampant. So the potential coworker, the witness, may not be in the
Yeah.
same city, anywhere near your injured worker. I've got a claim right now where the
Hmm.
supervisor, the direct supervisor, was in San Diego while the employee worked here in Oakland, right?
Yeah.
Because of remote work, right? And so
Yeah.
here we are going to trial. And you got people sometimes had another employer saying that their entire HR and payroll department was like in the East Coast.
Wow.
So if you had a wage dispute, how are you going to prove that up? If the judge is not going to allow remote testimony, it doesn't have to be a
Right.
remote trial, right? The remote appearances, there's a vehicle for that. So you have to be able to explain to your client, sometimes that limiting of the exposure means that premium we talked about now, because proving up your case at trial may be impossible or very
Right.
costly, because now you have to try and figure out a way to fly in personnel from all over the country,
Right.
right?
Right.
And maybe multiple times. In comp, trials are not consecutive days. Day one here, day one 6 months from now. We don't know,
Yeah.
right? So those kind of things are something to consider.
And this is a rough estimation, but I would say only 10% of requests nowadays for virtual trials really get granted. I think judges want you there in person for trials expedited. What's been your guesstimation on that front?
I agree. I agree.
Yeah.
The last trial that went forward for me on a virtual, it went virtual because I got COVID, and so like a week, a couple days before trial, so I did an emergency petition for virtual because we of course want to limit
Mm.
exposure to the public for that stuff. So I was out of commission, but so that did allow the trial to go forward, right?
Right.
So that saved the client some costs there because we didn't have to, redo the wheel, But barring that, I don't believe um, I've gotten any of them really approved. You know,
Yeah.
they just they're very hostile. I don't use that word lightly. I think judges just don't like it. Uh, to doing the one that the example I was telling you earlier, that was just a virtual appearance. One witness,
Mm.
I was requesting to phone in, right? And the rest of us were going to still be there because again, you'll see that especially with these larger employers, departments can be spread out across the US, and that
Sure.
is something you need, and we wouldn't know until you're doing your prep with the client how their org chart is, right? And if
Yeah. Yeah.
accounting is on the East Coast, oh man.
Last question here is something that we ask for all of our guests on Comp Corner. Where do you see workers' compensation in the year 2050? Let's get our flash forward machine going in 25 years. Where do you think we're going to be in 25 years?
That's going to be an interesting thing to see, especially here in California, where it's a very high cost of living. Um,
Oh, yeah.
and technology is very on the forefront of things. I've seen videos of the burger flipping robot, robots picking strawberries. So uh, you know
Hopefully not
uh,
robots doing podcasts, but yeah.
exactly, right. The whole generative AI thing that people are so focused on nowadays. So it's really hard to see where we're going to be in 50 years for me, especially when, just the technology now that we're seeing,
Yeah.
I would have told you was been pure science fiction not too long ago, right? It's kind of unbelievable where we are now. So, hopefully the robot overlords have not taken over in 50 years, but we'll see.
The future is unknown. Thank you very much, JP, for sharing. So, a little palate cleanser for 5 and 5. We like to ask 5-ish questions in 5-ish minutes. You ready to go?
All right, let's do it.
All right. Let's start off simple and light. Is it pronounced GIF or JIF? And I'm not talking about the peanut butter here.
I've always thought it was GIF, but people have told me it is actually Jif like peanut butter. So I don't know, but I think I've always pronounced it GIF my entire life, but maybe that's wrong.
I think it has to be Gif, right? Jif just sounds like the peanut butter too much. I think we have
Exactly.
to stick with it, right? Now, second one, a little bit more complicated, but we'll try and keep it true to the heart. Lumpia or chicken adobo?
Oh, definitely lumpia for me, for sure. For sure.
Nice. And you grew up in Newark, right?
I did. I did. If anybody even knows where that is, right? You know, because you grew up in Fremont, but for sure.
Yeah, I grew up in Fremont, which is for those of you know, there's Newark is a sister city, kind of pseudo next to Fremont. Um, but was lucky enough to grow up with a lot of Filipino friends, and my Filipino friends' moms always made a lot of the Filipino dishes, who are traditionally a lot of pork dishes. They were kind enough to make them with chicken for me, so I was able to have pancit and all that other yummy dishes with chicken. But I gotta agree with you. Lumpia is the only answer that makes sense. So another one that's true to your heart specifically: Star Trek or Star Wars?
Oh, it's got to be Star Trek for me all the way. That could be controversial for some, but definitely Star Trek. I was actually geeking out a little bit. My friend and I were just at a Star Trek convention a couple weeks ago, so
Very cool. Where was
definitely.
that?
San Francisco, Burlingame.
Oh, very
Burlingame.
cool. Would you consider yourself a Trekkie?
I think so. I think so. I mean, not as diehard as some, but I definitely enjoy me some Star Trek for sure.
Actually, that was probably a poorly phrased question. I think if you went to a Star Trek convention, I think I think by definition you are absolutely 1 billion% a Trekkie. So easy answer on that one, right? All right. How about this one? Biggie or Tupac? I know the answer. What's yours?
Oh, oh man, that's probably Tupac. I don't know. That's just that's a tough one. People of our generation. I don't know.
I go Biggie, and I've got into battles with friends over the years because growing up here in California, the answer was always Tupac, of course, because you want to rep your roots and everything. But over the years, I gotta say, Biggie's music has kind of transcended my view a little bit. I still love Tupac, but I gotta give the edge to Biggie on that one. Speaking of Biggie, JP, can you tell our listeners what is that picture in your background over there? What do you have on your wall?
So that is a picture of me in, well, my face at least, in what appears to be a very pimped out, fur-lined coat from the 1800s and a cane. So, and a very tall wooden chair, if one can imagine that. So, I think it's nice there. It's like right in the screen when I take my depositions, people see it. When people walk into my office, that's the first thing they see as they walk into my door.
Nice.
I have no idea. I just think it's an amusing little thing to have.
Tell us how you got that.
So my friends got it for me for one of my birthdays. They know I can be a bit eccentric at times, and I think they just thought it would be funny.
I like it. You got to share that with us one of these days. We got to share that picture around sooner than later. Now, as a person who tends to sometimes play blackjack, the question is, do you always hit on 16?
Always, I would say depends on what the dealer's showing, right?
Sure. What if the dealer has a 10? What do you do?
I'm more of a
Excellent.
poker guy, but definitely I would hit on that for sure.
Okay. How'd you get into poker?
Some friends just were into it, and for my first job out of college, I was a paralegal for like 6 years,
Right on.
and so uh, in that job, some of the coworkers I had, one of them in particular had a bunch of friends who liked poker. I liked poker at the time, and so we did a weekly poker match with those set of coworkers for a long time, and that so I really got into it then.
And how long was that? How long ago was that?
Oh goodness, that was like in 2004 to right before I started law school. So 2004, 2010, give or take.
So you're pretty skilled by now then.
Yeah. I mean, I haven't played in a while, but at the time I was definitely into it for sure.
Very cool. Now, since you did so well on the first five questions, we're going to hit you up with the well-earned bonus. Which came first, the chicken or the egg?
Has to be the egg. Has to be the egg. Because where the chicken come from? I mean, logically, my thought process is evolution gets us from animal to animal to animal. So maybe the egg the chicken sprung forth from, perhaps came from something that wasn't a chicken. So I'll say egg. I don't know.
I think that's the prologue. That's a current theory is exactly what you said. They think that there was an animal that was pseudo chicken that hatched an egg, and somehow over the many, many, many thousands of years or hundreds of years, whatever, we now have the egg. So I think you are the prevailing scientific theory is one that you register by, it seems like. So thank you, JP, for a round of 5 and 5. We appreciate it. A huge thank you to Amir Riabi and Tammy Welty for producing today's episode. Please email your questions to Comp Corner. Our email address is in the show notes. Thank you to JP Torres for joining us today. See you all next time on Comp Corner.